So welcome back from lunch, and Bruce Price here, and it's my distinct pleasure to introduce Dr. Francis Shen, who's speaking to us today on the future of neuropsychiatry and the law, two important words, promise and peril. Francis is with our MGH-based Center for Law-Brain Behavior and also Petrie Flom-sponsored Senior Fellow in what we do. I'm the co-founder, co-director, along with Judy Edersheim. But let me track backwards. So University of Chicago, BA, Harvard Law School, and then to get yet more education, PhD at the Kennedy Center in Government and Social Policy, I believe. Associate professor at the University of Minnesota School of Law at this point, where he has his own neuro lab, the Shen Neurolaw Lab, and does exploratory work in lie detection, for instance, which maybe in years to come you can speak to us about that as well. Then, importantly, he spent some time in Vanderbilt, or is he the MacArthur Research Director for Neuroscience and Law. There he produced probably the seminal text called Neuroscience and Law with Owen Jones at Vanderbilt. And if Ryan Darby's here, that's now Ryan's return to home as well. And he has, which is a big read, and hopefully in the next year or two, maybe the second edition will come out. But it is the seminal book. If you're a lawyer and you want to know about law and neuroscience, this is your go-to book. And his senior fellowship with us started last fall at the Harvard Law School. It was a standing room only, electrifying speech to his own group of lawyers, but it was fantastic. And then we saw the light, and with Tony Weiss, we agreed that you should be our speaker today. So it's with a great deal of promise and future and electricity that I introduce to you Dr. Francis Shen, the future of neuropsychiatry and law, promise and peril. Thanks.
Well, thanks to Bruce and to you for your interest in taking a few minutes to think about neurolaw and neuroethics. It's exciting to be here, and I want to start, well, first of all, I have no disclosures, but I want to start with this question. What is the current status of law and neuropsychiatry? And when I ask a question, like every other question, I find the answer on Google. So I asked Google, I said, Google, first, what's the relationship between law and psychology? And Google told me, well, there are 531,000 hits, there's a journal, there are books, you can do joint programs. Okay. What about law and psychiatry? Also, Google told me 500,000 hits, journals, books, lots and lots of stuff. Let's get a little closer, and I know this is both neuropsychiatry and behavioral neurology. What about law and neurology? Google tells us, 11 hits, 4 of which are from one book called When Worlds Collide, The Uncomfortable Romance Between Law and Neurology. And finally, what about law and neuropsychiatry? Google says, no results. And if you flip it, neuropsychiatry and law, no results. Now, part of this, of course, this exercise is a little silly, and some of neuropsychiatry and law is surely covered in psychiatry and law. But I do think it makes the point, and Bruce and I were just talking about this, that historically, as you know, as psychiatry and neurology had conversations, dialogue, and somewhat of a split, law went more with psychiatry and with psychology. And so we have robust areas and dialogue on that side, and we are just now catching up on the neuro side. And the question that I'd start with is, why don't we have more interdisciplinary conversation between whether it's neuropsychiatry or behavioral neurology and the law? And we can think about that and come back to that. So that's, I think, a good place to start. And so if we answer the question about the current status, I think it's fair to say it's under construction, which is also an exciting thing, and the reason that I love what I do, which is all of this stuff is new. Neuroscience and law are not traditional bedfellows, and I'll try and give you a sense today of where things stand and where they might be going. But why do this at all? That's another big question. Why neurolaw? Again, they're not traditionally put together. And my answer, my approach to this question of why should you mix neuroscience and law really builds out of something that happened in law about a century ago. So there's this thing in law, the precedent, legal precedent, stare decisis, and it's really different than medicine. So the way you practice medicine in 1955 probably doesn't have a lot of influence on the way you practice medicine in 2018. But that's not true for law. Because in law, the way we work is that we say, what should we do in 2018? Well, we should do it the same way we did in 2017. If you get the same case in 2018, it's just to do the same thing you did in 2017 because there was a decision in 2017 and you have to follow it, stare decisis and precedent. Well, okay, what do you do in 2017? What you did in 2016? What you did in 2015? And it goes back and back and back. And at the turn of the last century, in 1897, a very famous legal thinker, Oliver Wendell Holmes, said essentially, that's a crazy way to go about doing the law. He wrote an essay, a very famous one and influential, called The Path of Law. It ushered in what was known as the legal realist movement, and this quote captures what they were trying to do. He said, it is revolting to have no better reason for a rule of law than it was so laid down in the time of Henry IV, which is, of course, the logical consequence of going back and back and back. And we derive our law from English common law. Next point, it is more revolting still if the grounds upon which that law were laid down back in the time of Henry IV or back in 1945 or even 1982 have long since vanished. That was the idea of the legal realist movement, and what else he said in that article is that the man of the future will be, the legal man of the future will be the person of statistics and economics. It is the legal realist movement said we ought to be realistic about the way that markets work, about the way the world works, and that ought to influence law. So was Holmes right? Absolutely. Today, law and economics is recognized as the single most influential school of jurisprudential thought. You wouldn't think about doing law in the world of antitrust or in the world of market regulation without consulting a whole number of economists in related fields. So my prediction, my career as premise darn is kind of fast forward 100 years. By the way, I should take, that was 1897. It took about a century for law to figure it out. So we moved pretty slowly. But in another century, I guess that'd be 3017, will law and neuroscience also have a seat at the table and become influential? And I don't know if I'm right, but I think so, and I'll tell you a little bit about why. Bruce mentioned the lab that I run in University of Minnesota. Our motto is every story is a brain story, but two things should be said. One is that, as you well know, every story is a poorly understood or maybe not understood at all brain story, which is going to pose some real problems for the intersection of neuroscience and law. Moreover, every story is not just a brain story. It's not a brain in a vat. It's the brain engaging with the rest of the body, the microbiome, the brain produced by genes, the brain in society, right? We're the most social creatures. So it's not just the brain, but the brain is really central, and that motivates our work. We do empirical work. We do a lot of outreach and education work, and I want to just flag two groups that I'm affiliated with that Bruce mentioned if you want to know more in this area. One is the MacArthur Foundation Research Network on Law and Neuroscience, lawandneuro.org. I run the education and outreach activities, so I have the pleasure of going out to judges and attorneys and many others and trying to introduce them to neuroscience. And the other is the wonderful center that's doing amazing work that Bruce and Judy have co-founded and that is thriving here at MGH, the Center for Law, Brain, and Behavior. And I'll say in a little bit about one of the programs we're working on with the aging brain and dementia and law. So the little tour of NeuroLaw today will start with a blip from the past, because this isn't the first time law has tried to learn from the brain sciences. A lot of focus on the current trends, and then some speculation and inviting your own queries about the future. Let's start, however, with some modesty. This is not our current enterprise, which goes maybe about 15 years or so. This neuroscience and law dialogue is not the first time that neuroscience and law have become intertwined. I've written an article about it. I won't go through the details. I'll simply point out that over 100 years ago, this is some of the early issues of brain, they weren't just concerned about traditional neurological questions. They were concerned about ethical questions, about legal implications. Just one of the examples from 1905, the relation of the lunacy laws to the treatment of insanity, appearing in Brain, and there are lots of other examples. There are lots of, I think, positive ways in which neurology, the neurosciences, brain science have influenced law over the last century, but I want to highlight one way in which I think it hasn't, just by way of caution, and that has to do with what neuroscience can or cannot tell us about interpersonal violence and aggression. This is one of the several holy grails of neuroscience and law. For as long as there's been violence, there have been people asking, why would someone do that? And there have been those in science and in medicine, or before that, metaphysics or philosophy or wherever they came from, that said, I have an explanation for why they did that. Moreover, I've got a solution so that they won't do it again. Now, more recent versions of this, and I think well done, which are more on the research side, come from folks like Adrian Raine at University of Pennsylvania. I won't talk about his book, but I just want to flag it as appearing in 2013, The Anatomy of Violence, and in that book he talked about his research in which he scans the brains of those who've committed a homicide, compares them to control subjects who haven't, and tries to piece apart where he thinks there might be differences. What I want to point out is that the very same types of questions were being asked by folks in Boston 40 years before, Vernon Mark and Frank Irvin. They published a series of articles and then published this book, which drew a lot of fanfare. It was called Violence and the Brain. And this wasn't just an academic exercise. They made the papers. So Fortune magazine, 1973, scientists studying overaggressive behavior are now implicating brain damage from hitherto hidden sources, right? This was one of their patients, maybe you know her, patient Julia, in a pleasant mood before deep brain stimulation. And a lot of their research was premised on the idea that if we could figure out, and they focused a lot on the amygdala, if we could figure out what causes people to be impulsive and to be aggressive, we could solve that by cutting out that part of the brain. Psychosurgery was their intervention. This was an era where IRB looked a lot different than now, so when patients would come in for a seizure disorder, they also participated in research. Using technology in part developed by Delgado at Yale, they implanted the deep brain stimulation. Again, they focused a lot on the amygdala. They would have her in this pleasant mood. They'd press their button, and they'd send her into rage behavior. Right? It's a little hard to look at least for me. Here's the thing. You'd think that a book called Violence in the Brain that was trying to understand the underlying neurobiology of violence and aggression might be cited and engaged with by a book in 2013 called The Anatomy of Violence. But it's not. It's not even cited. And Adrian Stewart's friend, we had a little exchange, a friendly one. I said, why didn't you cite it? And he said, because I never read it, right? It came and it went. The era of psychosurgery came and it went. Why? In part because I think we did not know, in large part because we did not know nearly as much as we thought or some thought we did about the circuits underlying aggression. Last point, even 40 years before that, Egas Moniz wins his Nobel Prize for the prefrontal lobotomy. You know that, and of course we know the history. But you might not know that law was really interested in this too. Last thing I'll leave you with on the history is this quote from the Yale Law Journal, 1948. Quote, psychosurgery has startling implications for rehabilitation, and it is proving successful in an increasing number of cases. Perfection of so relatively simple and inexpensive a rehabilitative technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals. Now, thankfully, it was never used in wide-scale relief. There's sort of few anecdotes that might have been used here or there with some prisoner populations. But I just think that's a useful point to start with, that the brain is so complicated, and especially the circuits that law cares about are so complicated, that we've got to be careful about inappropriate and premature uses. And as enthusiastic as I am about the possibilities, I think it's important to start there. All right, but let's talk about what's happening. Lots and lots of neat stuff is happening. Brain science is everywhere, including the courts. This is data from Nita Farahani at Duke, just tracking the number of criminal cases where some sort of neuroscientific evidence shows up, and it's on the rise. Same thing from Debbie Deno at Fordham, her data showing that we're seeing more and more. These are just bar graphs of different types of MRI, CAT scan, EEG, and the like. I've gone back and looked at the history of EEG, which of course has been with us since the early part of the 20th century, and it's shown up in a lot of cases too. So it's in courtrooms. Neuroscience is also in scholarship. A lot of people are publishing. It's just a graph by year of the number of publications in law and neuroscience. It's showing up in policy, in legislatures. From an article that I published on neurolegislation, again, the data, this is just the bar graphs of the number of bills in our state legislatures across the US that cite neuroscience. It's showing up again and again. But when it shows up, it's important to note that in the policy context, in an adversarial legal context, the science is not neutral. So what I found, in perhaps not surprising, but important to keep in mind, is that neuroscience wasn't persuading Republicans to vote Democratic or persuading Democrats to vote Republican. If you have a pre-existing policy position, or in the law, if you're representing a certain side, you like neuroscience or neuropsychiatry or neurology if that expert helps your case. and you don't like it and you think it's inappropriate and a bunch of hogwash if you're on the other side. And that's a real challenge for the integration of science in a meaningful and ethical way into a minefield of policy and law. It's showing up in law classrooms. I think this is a really important trend. 3 years ago, Bruce and Judy helped to start a course that Judge Nancy Gertner teaches at Harvard Law School called Law and Neuroscience. It's our course catalog, and I co-teach it this year. And we're seeing more and more undergraduates majoring in neuroscience. This comes from Virginia Tech, which started a new school of neuroscience, and I was a visiting professor there in the fall to engage with the undergraduates on neuroscience and law. Harry Sontheimer, the neuroscientist there, has this wonderful quote, calls neuroscience the new English. Their school of neuroscience went from 50 students to 350. He thinks it will go to 900 students. And just as English majors don't major in English to become a next poet laureate, but rather major in English because they want to be great at critical thinking and reading and writing and become lawyers or whatever it is, so too the thought goes that you might not major in neuroscience because you necessarily want to go to medical school or do a PhD, but because you want to work with the human animal in nursing, in criminal justice, in consulting. And you want to know how that animal thinks and feels and acts. So I think we're going to see more and more of these majors, which means we'll see a generational shift. Just to mention our book, thanks Bruce for mentioning it, what I want to point out is that it's already outdated in some ways. It's also new. So 80% of the, almost 90% of the publications that are cited in there were just since I graduated college in 2000. So if I had said, as soon as I graduated college, boy, I really want to study law and neuroscience, 9 out of 10 things that were in the book were not published yet. To me, that's remarkable. Over 2/3 just in the last few years, and within the last 5, we really need to update it because things have moved fast. There are many, many intersections. I'm just going to talk about a few of them. And again, the big idea is that a lot in law hinges on what brains do, and to some extent, that creates an opening for neuropsychiatry, for neurology, for the neurosciences. But what exactly does it look like? Let me give you a few snapshots so we can feel what neuroscience looks like in a courtroom or in legal proceedings. I'll tell you what it doesn't look like. It doesn't look like this, and not just, there's a beautiful graphic, came from, I think, Scientific American, but it doesn't look like this because we don't just give jurors a bunch of brain data. In the same way that we don't just give them expert reports. It comes through people like you in this room. There will be an expert testifying. We've already had experts testifying. We'll always have experts testifying. And the question is, A, which experts, and what type of stuff will they bring with them in the courtroom? Will we see more things like this? Or here's a doctor who testified last year in a case against a mixed martial arts fighter who went by the name War Machine. And we see a lot of arguments like this, that some sort of brain damage that the defendant experienced is either exculpating or should be mitigating at sentence. So in this case, the doctor testified that his frontal lobe lesion on the war fighter's brain, on War Machine's brain could have caused this hypersexual and very aggressive behavior. And he was eventually convicted. It was not a successful defense, but we're seeing more things like this. Experts getting on the stand and not just talking about behavioral data, but directly talking about neuroscientific data. We're seeing at the other end of the age spectrum. Here's an example. Sumner Redstone case, right? Major money on the line and questions about the mental state of Mr. Redstone. And we see quotes like this. Mr. Redstone's brain scan was quite good for a 92-year-old, from one of his treating doctors, Richard Gold, in a sworn statement. Right? We're seeing reference to brain scans, which we had not seen, obviously, because it wasn't possible, say, 50 years ago. Here's a case that's big in our world and really captures, I think, a lot of the challenges of integrating neuroscience and law. This you're looking at, this person is now deceased, recently deceased, is Herbert Weinstein. He was a New York advertising executive, no history of violence, and one day in 1991, he comes home in New York and strangles his wife, killing her, then to make it look like a suicide, throws her out the 13th-story building of their home. He's arrested, he admits to doing it, but he's going to have an insanity defense. Nothing novel yet. We've had insanity defenses. They're not, as you know, very easy to win, but we've had them for a long time. And not surprisingly, he was going to have an expert testify about why he couldn't appreciate right from wrong in that moment. What made this case interesting is what you're about to see next. It's a picture of Mr. Weinstein's brain. He had an arachnoid cyst pushing up in the frontal lobes of his brain, and you can see both the MRI and the PET scan. And the question that the judge had, it was a case of first impression, they had never had this before, should a jury be able to see this image? Judges have to make these decisions all the time. Of course, Mr. Weinstein can have an insanity defense, yes. Of course, he can have a bunch of experts testify. But as part of that testimony, can they show a scan like this to the jury? What are the concerns? Well, a major concern is how much research do we have linking abnormalities like this to any sort of behavioral outcome, let alone the behavior that's at issue in the case? Answer, 0. The answer was 0 in 1991. The answer is 0 now. The answer will be 0 for many, many decades to come. Well, okay. Does that mean you keep it out altogether, or do you allow it in and then allow cross-examination and another expert to come up and tell the jury why this is so problematic? We do that a lot. Battle of the experts. Which leads to one of the unique questions about neuroscience and the work that you do. Would this be especially persuasive to jurors? Would there be a reason that they would see this and then forget about all that they're talking, but look at the guy's brain. Of course there was something wrong, right? It's plausible, but what is the causal connection? In this particular case, the judge made a ruling that the jury could see the images, but that the expert could not testify as to causation. Mr. Weinstein ended up on a plea deal, so we don't know how it would have been received, but I'll show you an example in a moment where we have seen brain science show up and have an effect. I want to note that one of the places where brain science has had its most significant impact in law concerns juvenile justice. There are a series of cases, these are the first two, Roper v. Simmons in 2005 and Graham v. Florida in 2010, and since a case called Miller. And in these cases, the U.S. Supreme Court has considered whether the U.S. Constitution's prohibition on cruel and unusual punishment should prohibit giving juveniles the death penalty. Answer now, yes, you can't do that. Should it prohibit life without the possibility of parole for non-homicide juveniles? Answer, yes, you can't do that. And should it prohibit automatic life without possibility of parole, even for those who murder? And the answer is yes. And in each of these cases, brain science was implicated. Though this is an example of group neuroscience data. We don't have any data, and none was proffered, on the brain scans of Mr. Simmons or Mr. Graham. Instead, we had amicus briefs filled, and from the APA and the AMA, filled with discussion of the developing brain and arguments about differential development of prefrontal cortex and limbic system, arguments that led to their conclusion that on the basis of this neuroscience, juveniles as a group, maybe all the way up to age 25, are less culpable and more amenable to change. And the US Supreme Court cited to some of this research in its findings. It's been a major source of both excitement and debate, and this raises the issue of group to individual inference. In dissent to these cases, the dissent pointed out, well, wait a second. This isn't Roper versus the class of all 17-year-olds in the world. This is Roper versus one individual, Christopher Simmons. And if we had more time, we could go into the details of what Mr. Simmons did. In a nutshell, he said he wanted to kill someone. He planned it out. He found the old lady. He duct taped her with his friends, and he threw her over into a river and watched her drown, and then bragged about doing it. This wasn't an impulsive, entirely impulsive thing. And the defense said, what evidence do we have that Mr. Simmons isn't one of the rare juveniles who actually is just as culpable as the adults? The group to individual inference problem is a real challenge. These illustrate that. I want to give you one more video, because those of you who know about the criminal law know that most things don't go to a jury. 95% of cases end in a plea deal. And what that means is the prosecutor talks with the defense attorney who's in conversation with the defendant, and they reach an agreement. It's much more efficient, and there are questions about whether it's just, but that's the way the world works. Could neuroscience play a role there? Neuropsychiatry play a role there? Well, it hasn't much yet, except for one innovative lawyer. And what you're about to see is his video explaining what he does. The scans you're going to see are SPECT scans coming from a Daniel Amen lab in Florida. Yes, you already see the problems here. But let me just complicate your analysis. Because Attorney Cobb, who I've spoken to, and I hope to spend some time with him this summer, isn't hired to do a PubMed search for his clients. He is hired to argue vigorously on behalf of his clients and to get them the best deal he can. And by the way, many would argue to get them a deal in a system that is slighted against them. Okay? That's his job. And he reports that he's received some better outcomes doing what you're about to see. So how do we evaluate this use of neuroscience? Right? To what extent does that require a consideration of the justice system, or do we just focus on the science and say, this is crazy? Why would we use that? We can't lower the bar of science just to achieve a desired outcome. Open question. But I want you to see what's happening, because this is not oh, maybe someday a lawyer will think about using brain scans. No, this is happening. It's already happened. Take a look.
Because most cases settle. That's the truth. So how do we handle that? Well, one of the things that is most innovative about our law firm is we're the first law firm in the United States, if not the world, to use neuroimaging for damage control in criminal cases. What do I mean? Well, take a look at the pictures on the screen right now. Those are pictures of a healthy, normal range brain image.
But wait, the next one is going to get
when
you.
you see the next set of images, this set of images right here, you can see these are completely...
Okay, so that's all you need to know. But the law has a tough time evaluating that. And indeed, my students will split right down the middle if I ask them, is this a good use of neuroscience? Would you do the same thing? Even my students who understand the neuroscience and understand why those images are so problematic. Because they would point to all of the problematic evidence that the prosecution regularly uses. They would point out that it's not their job to do these things. They would point out that, look, it's not like as if he went to PowerPoint and just made those things. The attorney went to someone with credentials. I understand, the limitations. But that's the challenge that law faces. It's not just a science question. It's a science and a justice question, science and an ethical question. Now, I'm strongly of the view, so you know, that it's extremely problematic to do that. And indeed, I think it's very problematic for our field if there are continued inappropriate and premature uses on the grounds of, well, the ends will justify the means. Because I think it will muddy the waters and deep six our longer enterprise. But it's challenging. And if I were an advocate and didn't have the benefit of being a neutral academic, maybe I would say something different. So where is all going? I think we can think about things in terms of regulation, tools, and concepts. Regulation, the governance. For example, how should, as a policy matter, we respond to Alzheimer's diagnosis? Does that mean automatic revocation of a driver's license? Tools. This is a world, and I hope to speak with you maybe some of after, the ways in which tools are changing slowly your practice. Might they change forensic practice as well? Whether it's neuroscience, lie detection, or something else. And maybe I'll note in the back, I think the clicker may have stopped clicking, so maybe you can advance for me or get, there we go, okay? And then finally, concepts, deep conceptual questions. And in particular, how do we reconcile laws, categories, guilty or not guilty, this or that, with probabilistic neurobiologic data? And we'll give you some examples of that. So let me walk you through where some of this might be going. This comes in part from an article that I recently published, Law and Neuroscience 2.0, the theme of which is balancing excitement and caution. Why should we be excited? Well, there are a lot of reasons to be excited. For instance, more and more people are studying the brain. And it would be astounding to me if these tens of thousands of people and hundreds of millions of dollars over the next decade, maybe the next 5 years, certainly the next 50 years, didn't make fundamentally new discoveries about the way the brain works. I think that's a safe assumption. I think it's also exciting that it's not just neuroscience, it's the biosciences, it's artificial intelligence. I teach in that area as well, machine learning, all sorts of other stuff that's happening. So there's a lot of reason to be excited. But there's also a lot of reason to be cautious. And again, this is the audience to talk about it in clinical practice. Steve Hyman asked several years before DSM-5 came out whether neuroscience could be integrated into DSM-5, and I think the answer is very clearly not yet. There are, I think, wonderful commentaries coming from psychology, one called Mistreating Psychology in the Decades of the Brain, where this intellectual modesty is in order. And I think that's right. There is right now, in my view, a great disconnect. If you read the abstract from molecular psychiatry, and then you walk out on the street and see, what's our kind of modal treatment for addiction? There's a massive, massive gap there. Once that begins to close, however, law is going to have to catch up. So brain science might not matter for law. Let's try and think about where it might or where it might not. So regulation in society, again, the big question is, by what criteria do we evaluate or promote or criticize brain science in the public sphere? And just because it's fun, but also makes a point, I want to show you a 30-second clip It needs no introduction other than to say you might have heard of this group, Lumosity, and they're targeting some of the people in this room with this ad. Here it goes.
I worked hard to retire early, but I didn't want my brain to retire too. I mean, I stay active, but it's just not the same. Lumosity is real science disguised as games, so I enjoy doing it. It's a fun part of my day. My brain feels as good as ever, and it's way better than work.
Any brain can get better, and Lumosity.com can help. It's like a personal trainer for your brain, improving your performance with the science of neuroplasticity, but in a way that just feels like games. Start training with Lumosity.com right now and discover what your brain can do.
If you counted it, they used the word brain multiple times. Neuro, brain. They could have just said mind. Why are then they've got ads for everything. There's an open academic debate about whether or not playing these games just makes you better at the games or provides some long-lasting cognitive function. This becomes a legal question because they're making these claims in the public sphere, and Lumosity was hit with a major fine from the FTC because their claims, not that particular one in that ad, but their collection of claims didn't hold up. By what criteria will we say, okay, you can make those claims or not? We're seeing, one thing to mention is cognitive enhancement. It's been an area of much investigation. I spent some time in our lab thinking about it. There had been a prediction from a guy named Alton Spillhouse, who was a futurist, and he made this prediction 50 years ago, and it still holds true. By 2016, man's intelligence and intellect will be able to be increased by drugs and by linking human brains directly to computers. And we're almost there. And that raises a lot of questions. And again, you are going to be at the center of it because of headlines like this. Minnesota high school students taking Adderall to boost academic performance. Should this be encouraged or not? And you as Gateway, what would you do when someone comes in and says, I don't have, and you do your analysis and there's no formal DSM diagnosis, right? That symptom-based diagnosis doesn't give them the label of saying having ADHD, at which point the logic is that it's not cheating or enhancement, it's just allowing them to be their normal selves, to achieve what they would have but for this detriment. What if somebody says, my detriment is, look, I'm a B student, but I really should be B+ or A? How am I going to get into Brown if you don't give me a little help? You know? What is your ethical framework for evaluating that criteria? And it turns out it's a really tough question. Because if they came to you and said, do you recommend getting more sleep? You'd probably say, yeah. Do you recommend this sort of diet? You might say yes. So why is that, which is brain enhancement, what's the mechanism of action? It's neurological. What's the difference between also saying, do you recommend this set of drugs, right? And if it's just a technical engineering question, well, we don't know enough yet, well, that will be solved. If it's a deeper ethical question, it's more challenging. It's also a legal question. Is it academic dishonesty to do these things? By the way, at Minnesota, at the law school, we actually do give our students drugs. It's called caffeine, and around exam time, we just lay it out there. And again, we don't think it's cheating, but why not? What is the difference between that enhancer and a different type of drug enhancer? And again, this group is really at the forefront because although there's illegal activity, a lot of it's going to be legal prescription as well. Regulation in the courtroom, I mentioned before, there are lots of these, my brain made me do it, places. I'll just mention two things that have happened. You might say to yourself, well, what would jurors think of all this? And we got one case that gives us some really interesting, tantalizing evidence. It comes from this case. This you're looking at is Grady Nelson. Mr. Nelson was uncontested, did horrible things in Florida. He stabbed his wife over 60 times and killed her. He attempted to stab and kill his stepchildren. Thankfully, they lived. And he had a history of sexual assault, abuse. I mean, you name it, it seemed like he had done it. And the only question really in this litigation was whether or not he was going to get life without the possibility of parole or the death penalty. And his attorney, Terry Lenneman, set it up exactly. They really didn't contest the guilt phase. They were all geared towards trying to avoid the death penalty. And their major, and it turns out persuasive piece of evidence, was this quote-unquote brain mapping evidence offered by Dr. Robert Thatcher based on his QEEG analysis of Mr. Nelson's brain. You know, Thatcher gave his scientific testimony, but translated by Terry Lenneman to the jury, his words were, ladies and gentlemen, my client has a broken brain. It doesn't excuse his actions, but it explains them. So jurors don't have to talk to anyone after they make a decision, and they tied 6-6, meaning that Mr. Nelson did not go to death row, but is serving life. But 3 of the jurors afterwards, they have the opportunity, they talk to the media, and I'll just give you their own words, and I think that speaks enough. Juror Dolores Cannon, a hospital secretary, quote, when the brain evidence came in, the facts about the QEEG, some of us changed our mind, end quote. Juror John Howard, an airport fleet services worker. Quote, the QEEG evidence turned my decision all the way around. The technology really swayed me. After seeing the brain scans, I was convinced this guy had some sort of a brain problem, end quote. Final quote, they didn't all buy it. Juror Leon Benbow, a retired mailman. All that scientific testimony, that was a waste of taxpayer money. That's phony. There's nothing wrong with that guy's brain, end quote. So, again, was this a great use of the science or an inappropriate one? Now, I'm on record, I should say, as saying it shouldn't have been admitted. There was a Frye hearing. Those of you who aren't familiar, Frye and Daubert are the two standards. Frye is in some of the states, and it said, has this method been generally accepted? Well, yes, QEEG is generally accepted for a lot of different sorts of uses. That was the argument that was made. But no, it's not been generally accepted to try and evaluate whether or not someone had some of a lack of criminal culpability that it claimed it is. But the counter argument to my position is that there is a man that is not on death row in large part because of the brain scans that you're watching. Is that an appropriate use, a use of this to be celebrated or not? And whatever your answer is to that, you know what happened the week after this happened is there was a big press release from Terry Lenneman telling his fellow attorneys, hey, I just did this, use it. Of course, Dr. Thatcher is also out there proffering his wares. And so whether you think it's a good thing or you're concerned about it, as an empirical proposition, I think we're going to see more of it. And the work in our lab and the work in our field is to try and navigate this. All right. One of my favorite cases and one of the holy grails of neurolaw, lie detection. There have been two actually, fMRI-based lie detection cases where a judge has had to decide, do I let a jury see this? Let me tell you why that's so important, that judge's decision. It's not just what happens in this case, because remember, law is precedential. If a judge were to say, yes, here in Tennessee, you can admit this brain scan lie detection evidence in 2010, that means that in 2011 in the federal system, someone might look back and say, aha, I don't have to go through all this careful analysis again. They already let it in. Okay, I'll let it in here too. You can imagine this domino effect. Here was the case. This is Lawrence Semrau. This is the best picture I have of him. You can't really see him too well. He was a medical doctor, but he was really doing his business Medicare, Medicaid billing, and would give these services out around Kentucky and Tennessee. And you all know the billing system. There are all these codes, and you send them in. Well, he just so happened to every time be sending in codes that paid them back a little bit more than they were supposed to be paid. And he did this over a period of about 7 years. In order to find him guilty of Medicare, Medicaid fraud, they had to show that he knowingly did it, knowingly devised this scheme. And his whole defense was, it was just a big mistake. He even said, we called the 800 number. It's really complicated. I mean, I'm sorry, we didn't know. And one of the pieces of evidence he wanted to proffer was testimony from this person, Stephen Lakin, who at the time ran a company called CFOS, Lie Detection Services. I'll read it to you. Using state-of-the-art functional magnetic resonance imaging technology, CFOS provides independent, peer-reviewed, published scientific validation to a range of situations. If your word, reputation, or freedom is in dispute, contact the CFOS team today. So he did. The lawyers did. And Lakin did these fMRI brain scans, actually right here in Massachusetts. And he wanted this report to go in front of the jury along with the scans. I, Dr. Stephen Lakin, conclude that Dr. Semrau's brain indicates he is telling the truth to not cheating or defrauding the government. And again, the judge had to decide, do I allow the jury to see this? Now, I'm on record as saying it should not have been admitted, and it was not. And in another case, it was not. Why was it not? Well, the science just isn't there. If we have more time, or if you want to, we can talk about why it's not there. We've gone on at length about it. At this early stage in its development, it just doesn't meet the requirements. And in large part, it doesn't meet the requirements because we don't know what the cognitive state of lying is. So how can you identify the underlying neural correlates of a cognitive state that you can't specify, right? And that's a big problem for law in general. Moreover, they were concerned that, well, it's not just that it's shaky, but it's the sort of shaky evidence that might really persuade a jury. And we've seen this theme show up. I'll just close this little segment by saying that one of my predictions about where this data is going, this is the slide you saw before, is the following. One thing I notice about the data is that although the trends are upward, the overall N is actually pretty small. It's a little too hard to see, but on the y-axis, the large number at the top is only 350. Now, these are just criminal cases from Professor Farahani's data, and they undercount the total use. But even if they undercount it by 10, there were maybe 10,000 cases. That'd be important, but the denominator of all criminal cases in the US in a given year is so vast that we're talking about neuroscience showing up in a really small number of cases. Does that mean that neuroscience isn't important? I would say no for two reasons. One, some of those cases are just really seminal. Right? They're really, really important, like the Juvenile Justice Supreme Court cases. The other reason is that you don't need neuroscience if the outcome is not in question. So I've argued that neuroscientific evidence might end up in part being like instant replay. 90, 95 or more % of professional sports plays don't involve instant replay. Why? Because you don't need it. When do you need it? When the stakes are high, like did he score the touchdown or not? When the foot is like right on the line, or crucially, when you really disagree with the call that someone made on the field. And so now it's become routine to see images like this. Go to the video, go to the video. The last 2 minutes of the game, we're gonna see it March Madness. We know was he out of bounds or not? And they'll spend like 3 minutes giving us every conceivable replay. Did he touch it or not, right? That was impossible to do. We did not see images like this even 50 years ago. And we didn't see images like this until all that recently. And I think that it might be the case that in those legal contexts that are the equivalent, where the stakes are really high, where you actually have the technology, that's, by the way, another theme in our work, is cost a lot of money to bring you people into our courtroom. Who can afford these things? Is it a mistake that it was an advertising executive and a Medicare provider who had the wherewithal to do this? It's not. In death penalty cases, the state is much more willing to give funds. We've seen it a lot more there. So the technology costs are going to have to come down, or else we'll have some inequality. But if you have access to these resources, if you have video that you can go to, or if you have brain scans that you can go to, we might see it. All right. I mentioned some tools. I'm just going to mention these, and there's not really time to go into them. But I think there's a lot of promise in EEG-based memory recognition. We're working on some of this in our lab. The idea is that we just showed random person, random person, random person, your mom. As soon as you saw that picture of your mom, there's a brain response that can be measured with event-related potentials, and there's some neat forensic applications. I'll just tease you with that. I'll tease you with other work that the Center for Law, Brain, and Behavior has done on pain. And I noticed, on the shelf outside, many books on pain. Is it possible that we'll have some, even if not perfect, better than what we've got for pain meter? Our colleague Amanda Postilnik and the center is investigating that. The answer is not yet, but maybe. And there may be some places where subjective measures of pain aren't available. Here's an example. You're prosecuting elder abuse case, and your primary witnesses all have Alzheimer's. Right? What if you had some objective data of the pain that individual was feeling? Could it be introduced? This is a big deal for me, biomarkers, which are really not biomarkers, but biosuggesters, and it's this probabilistic nature that's going to cause all sorts of problems for law. And I don't know how the law is going to handle it, but it's one of the things that we're looking at. And I'll just give you an example in the context of capacity and the neuroscience of aging. We've got a big program coming up on decision-making fraud and undue influence. If you're here, you should come by. We've also looked at aging judges and aging politicians. And again, the issue here is that the symptom-based approach that we take can lead to many conflicting inferences. Is there something that neuroscience can offer? And how do we not get out ahead of ourselves? So here's an example of what we ought not to be doing. But this was a company. This comes from a real website that thankfully isn't there anymore, but was there, Mind Genesis. Our goal is to provide the comprehensive and definitive imaging services required for confirming the presence or absence of Alzheimer's disease at the earliest point possible. We can't do that. Well, whose role is it when someone says, yes, we can, to jump in? It's the law, right? But what if you could do that? And how does the law know whether this is possible or not? Right? Law isn't trained, neuroscience. We need the dialogue. And we are going to see more and more of this stuff show up. What are the legal implications of early detection, of elevated risk for Alzheimer's disease? I'm not talking about like early onset. I'm talking about on every behavioral battery, perfect. Conscious experience of life, I feel great. Yet we identify changes in brain and maybe also blood that suggest that the brain is already changing in ways that probabilistically suggest some very heightened risk for some mental disorder. We just heard a talk last night from Chuck Nelson, if you know him, and his work on childhood development. That's what they're working on at the beginning of life too, biomarkers for childhood abuse and adversity. And these are really challenging. Here are a bunch of questions. What if rights should be taken away on brain circuit abnormalities? Right? when should it be admitted in a courtroom? What would that mean? How can our legal categories, undue influence, incapacity, be informed or not by neuroscience? And what if you start relying on some of this evidence? How do you do it? With what qualifications, and how will that show up in law? And I've mentioned this before, what if they're needed to testify to the pain? And we can ask this question for a lot of things. There's work on autism that's happening. We've explored that as well. So there are big concepts as well. Again, juvenile justice, I mentioned all sorts of mens rea. That's the criminal mind questions. I love it. We've published a lot on it. No time to talk about it, but there is time in the last couple slides just to mention the addicted brain. Law and addiction has a long past. The leading case law, Supreme Court case law on addiction, remains 50 years old. Right? So imagine decades and decades and decades of neuroscience research. I mean, we've all seen those little mouse videos from the 60s, right? We've known about the dopaminergic reward system for a long time. All this amazing stuff going on, and yet the law's position on addiction remains rooted in an older era. This was the question back in 1952 on the addict and the law. And the question today, here in Massachusetts, the question before the Massachusetts Supreme Judicial Court, and we ran a program on this at Harvard a few weeks ago, concerns this woman, Julie Eldred. Miss Eldred is an opioid addict, went clean, and part of her probation requirement, so if you're on probation, there are a lot of requirements. Can't do this, can't do this, can't do that. One of her requirements was stay drug-free. Well, she did not stay drug-free. And she is arguing that it's unconstitutional to require her to stay drug-free, because it's roughly the equivalent of telling someone, you just can't develop colon cancer. Just decide not to develop colon cancer. If you just willed yourself, you could not do that, right? Saying, I didn't have a choice, not a meaningful choice. And that is now before the Massachusetts Supreme Judicial Court. Now, the flip side argument is, well, would you also not have a probation requirement to say that you can't hit someone, you can't be violent? Would someone say, I'm sorry, I just can't, my brain is wired such that I can't help myself doing that. It's unconstitutional to require me not to hit someone, right? Really deep questions, informed by neuroscience, wrestled with by law. So, I don't know where this is all going, but I do think that three things are clear. We need more research, obviously. We need more education, and we're trying to do that, through these programs. We need more action. Tomorrow, actually tonight, I'm flying out to present tomorrow out at Stanford on a proposal for a neurolaw clinic, where we would integrate expertise like yours in a meaningful way, in a thoughtful way, so that we don't have these ridiculous brain scans showing up. But that, on the other hand, we don't say, boy, you all have been learning about the brain. You have, how many edited volumes about the brain and mental disorders are sitting outside right there? And you know how much law thinks about those? Very little. Is there not some room for dialogue and integration? And I guess that would be the very last thing I say is that, and this was the theme that I mentioned at the beginning, we need more dialogue. And it starts in places like this, and I'm just really appreciative that you're willing to jump into these questions. They're not easy to solve. We have to think about the science, what's possible, what do we actually add for value, what's feasible, and is it ethical? And it is not easy to answer those things, but I appreciate that we're going to try. So thank you very much, and I think there's still a few minutes for questions. Pretty sure.